Good evening, Dr. Dilip sir.
हेलो कैसे है जितेंद्र भाई?
Yes, I am fine, sir.
या
Sir, for the viewers, I will introduce Dr. Dilip Walke. Everybody knows in Foxy. Who is he? He was immediate past president in Pune Obstetric and Gynecological Society. In 2007 to 2010, he was Ethics and Medical Legal Committee chairperson in Foxy. And I was one of the member in his committee. So we all are followers in Ethics and Medical Legal Committee of Dr. Sanjay Gupte, Dr. Prakash Pawar, then Dr. Dilip Walke, then Dr. MC Patel, then Dr. Hitesh Bhatt. So they are in line, and I am the last one now in the line. So he is also advisor and partner in one app for telemedicine and for OPD solution. That is Dr. Dr. Prex. Okay.
डॉक्टर प्रैक्स. हाँ.
So he is taking advantage very fast for telemedicine as it has become legal now. So from after 25th March. So welcome, Dr. Dilip sir.
Hi Jitendra. One thing you forgot to mention in my introduction, that Dr. Valke is well connected in
Yes.
Foxy, and one of my best connection in Foxy is Dr. Jitendra Sharma. So that is one very important part of my biodata.
Yes, sir.
So Gitendra, I must congratulate you for this YouTube channel that you have started. A wonderful activity of question and answer. And actually, I was waiting for my chance to ask you question, and I must thank you for giving me this chance. In fact, I must tell the viewers that I have been taking advantage of my friendship with Gitendra Sharma since long time now. These question and answers, the first time that we are doing a video on that, but otherwise I have been calling Gitendra at odd hours to take advice about various matters of medico-legal aspects. And because I consider Gitendra as an encyclopedia on medico-legal issues, so that's how I know Gitendra. So actually, I'm going to take advantage of the fact that today I've got a chance to ask some question. So today, basically, Gitendra, what I want you to discuss with the viewers is a nightmare-like situation that we often have to face, and that nightmare is when you are actually operating, or maybe you're managing some patient. What happens is there can be a death on table. Just a moment. I lost my video at my side. That's why. So there can be a death on table. I mean, during the surgery, or death during the treatment itself. Now, what happens is, no sooner than this thing happens, this kind of a death happens, and I am telling you by my own experience. No matter what you may be telling as a medical legal experts to tell the people, do not panic, but the first thing that happens with anybody is that we tend to panic, and then many questions come in our mind. Now, will I be arrested, and what is going to happen? Is the police going to refer this case to a medical college for opinion? And what if I'm negligent in management? How will the medical college people consider me to be negligent? And if they decide to arrest me, the one thing that everybody is worried about is, am I going to get the bail immediately? And no sooner than I go to the police station, am I going to be detained there in the police custody for a day or two, and then the next day morning I go to the magistrate, and then the magistrate gives me a bail? I mean, like a typical criminal, you are arrested and then you are in the police lockup for a day or two. So these are the kind of questions that come in our mind. And is there any solution like an anticipatory bail so that I'm never arrested? So what I want you to tell Gitendra, and to make everybody aware, is about that 304, 304A and the different IPCs, and how, when there is a death on the table, how does the case go? That's what I thought I should ask you, and the viewers will benefit by your answer.
So basically, we have to understand the difference between 302, 304 and 304A. So if we know that difference, then we can definitely be fear-free. So basic purpose of our campaign is to make our fraternity fear-free, not to make them fear, but we want to make them fear-free in practice.
Correct.
Now, there are three basic things in any act, or I can say the crime, the first is act, action should be there. Then second is intention, and third is knowledge. Now, basically, we discuss every time 302, 304, and 304A. So, dear friends, 302 and 304 are the sections of punishment actually. So, they are not the sections of a crime. So, actual crime sections are section 299, that is for culpable homicide, and section 300, that is section related to murder. So actually the section should be applied to 99 or 300. But it is a defect that people are directly applying section 304A or 304. So that is wrong basically. That is the section of punishment. Now let us understand what is the difference. So if your act is done with intention and with knowledge, now if you intentionally do cause some bodily injury or some injury to the person, another person, and if you are sure that your act is going to cause death, or your act is of such intensity that it is going to cause death of the patient, then it will amount to murder. So that is 302 section will be applied, and punishment under 302 is death sentence or life up to life imprisonment with or without fine. Now, what is 304? Now, 304 means it is culpable homicide not amounting to murder. But in 304, there are two parts. The first part, that is part 1, which says that any act done with intention, without knowledge, that falls in part 1. And second part, it is with knowledge, without intention. So here, out of 3 constituents ingredients, 2 ingredients are present. In part 1, intention is there, knowledge is lacking, and in part 2, knowledge is there and intention is there. So in 304 part 1, it is never applicable on medical negligence, because nobody can doubt the intention of doctor that he will kill the patient. Okay. Now second part, sometimes police person apply 304 part 2. Now there is only little difference between 304 part 2 and 304A. That's why police sometimes take advantage and file case under section 304 subsection 2. Now 304 subsection 2 means act done without intention but with knowledge. Now what is the example? Suppose I am living 10 minutes away from my house, from my hospital, and I got a call from the hospital that, sir, a patient of registered patient of central placenta previa has landed in the hospital with severe bout of bleeding. Please reach earliest possible. Now suppose I am within 10 minutes away and there are guests at my home and I don't reach at place even after 1 hour and patient dies. So that means, although my intention was not there to kill the patient, but I had knowledge that if I will not reach at the earliest possible, then it may lead to death of the patient. So here the knowledge was there, and in such case, police person usually apply 304 part 2. Now what is 304A? 304A means here the act is there, but there is no intention to kill or no knowledge is there. So suppose you are driving your vehicle at the speed of 40 and suddenly somebody comes in front and dies due to accident. So that is a rash and negligent act causing death. So there is no intention and no knowledge. Now the basic difference in between 304 and 304A, in 304 part 1, which is not applicable, but in which the punishment is up to life imprisonment or minimum up to 10 years imprisonment with or without fine. And in section 304 part 2, the provision of punishment is up to 10 years imprisonment. So it is non-bailable basically. 304 is non-bailable, and 304A, here the punishment maximum is up to 2 years imprisonment, and 304A is bailable. So if police person files case under 304A, then nothing to worry, because you are going to get bail as a right, and even police person can give bail at police station level. So don't worry for that. Nobody is going to arrest you. But if 304 is applied, so that is non-bailable. So in such circumstances, police can arrest. And if police arrest, then within 24 hours, they will produce you in the court of law. And there you can definitely demand for bail. And if bail is granted, then you will be free. But you will get bail through court because it is non-bailable. Okay. And if you don't get bail, then you have to be in jail. So in these circumstances, it is advisable that if 304 is applied, you should flee away at least, or you should hide somewhere, and you should apply for anticipatory bail in anticipation of the arrest. And if you get anticipatory bail, then you may not be arrested. Okay. Now, there are certain cases decided by Supreme Court, and in those cases, it is not directly mentioned, but indirectly it is mentioned that in medical negligence cases for criminal liability, the cases should never be filed against doctor under 304, and all cases should be filed, even if required, then they should be filed only under 304 subsection A. So that is a great relief. Our friends may not know such cases, so there is a need to know all such decided cases by Supreme Court, which has clearly guided that a case under 304 should not be filed for medical negligence. It should be only under 304A. So if it is under 304A, then you are not supposed to worry because it is bailable. And always Jacob Matthews case is there. You all know that no FIR can directly be taken by police person if it is not associated with some expert opinion of similar stature, doctor of similar stature or similar fraternity. Second, if that expert opinion is not there, then it is a duty of police officer to ask the opinion of independent, unbiased committee formed in nearby government hospital, preferably in government hospital, and which should contain the one of the member at least from the fraternity from which you belong. And if that committee gives the opinion that there is negligence, then only case can be filed against doctor under 304A. And the third observation, which was third guideline, which was given by Supreme Court, that doctor cannot be arrested in a normal routine manner. So handcuff cannot be applied on doctors. Even if doctor is to be arrested, he may be called at police station. He may be allowed to sit down in the police station, and he may be, I can say, put in front of court, and court will decide that whether bail is to be granted or not to be granted. So nothing to worry. At least for criminal liability, you should be fear-free. And it is my observation in the last 15 years that under criminal liability, a very, very, very few doctors are being punished. Okay.
Yeah.
So at least for criminal liability, nothing to worry. And if you are being properly represented in the court of law, I can definitely assure you that you will be exonerated or acquitted free of any criminal offense. So hope I am clear, sir.
Yeah. Jitendra, the last sentence that you said, that you have to be properly represented in the court of law. And that's why I look upon you many a times when somebody asks me about advices on medical legal aspects, I refer those cases to you. Because you are the one who represent them properly, and not only represent in given case of medical legal aspects. I can, while talking to you, I know you are, there is an activist in inside you, and many times you keep on thinking about what about this new judgment which has come on consent, and you want something to be done for that. And this the new Consumer Forum Act that has come of 2019, and you feel like doing something about it, something good should happen for the fraternity. And that's the reason why people like you should not be just practicing medical legal law practice individually, but you should be getting some post in some organization, so that the organization also starts working in this direction. And that's the reason why I it's my dream to see you in a month's time as the next vice president of Foxy. So I wish you all the best for that too.
Thank you, sir. Thanks a lot.
Yeah.